SJC-12107, James H. Dunn and another v. Attorney General and another.
Good morning, Ms. Spohn.
Good morning. May it please the court. My name is Catherine Spahn, and I'm here today on behalf of the voters, including our plaintiffs, James Dunn and Diane Sullivan, who join us here in the courtroom today. We're asking the court to enjoin the placement of Petition 1511 on the November ballot for two reasons. First, the petition contains unrelated subjects, and second, its policy statements are improper under Article 48. Petition 1511 contains two separate and distinct provisions. The first would prohibit animal confinement practices in the Commonwealth, and the second would restrict products retailers can sell within the Commonwealth.
But isn't it restricting the products that retailers can sell that have come out of animal cruelty as it's defined in the statute?
That is correct, Your Honor, but the problem is the misleading nature by which the petition is formulated and drafted, which focuses exclusively on the animal confinement prohibition with little or no mention of the substantial burden that would be imposed on retailers in eliminating affordable protein options within the Commonwealth.
But that's the thing which I am perplexed by. That speaks to the single sentence statement, which makes no reference to the sale. Have you challenged the yes statement?
We have not, Your Honor. We have not challenged the language of the yes-no statement itself, and we acknowledge that. But what our concern in pointing to the yes-no statement is exactly the kind of voter confusion that will stem from this petition, which is the focus is exclusively on the animal confinement provisions with no mention of the burden on retailers.
But you've challenged the relatedness issue, not the statement. And are they not related in that if there is no prohibition against sale, it will essentially mean that farmers who comply with the new law would be priced out of the market?
Article 48 talks about the lawmaking provisions for the people, and it affords certain protections for make the Attorney General's certification the first and last line of defense to prevent voter confusion. As this court found in Carney, the confusion of the petition relating to promoting the humane treatment of dogs was confusing to the voters, and that's exactly what's happening here again.
But I mean, the summary makes reference to the sale.
Yeah, the summary does make reference to this.
So the only thing that arguably is confusing is the one thing that you're not challenging, which is the single statement.
And what we would argue is that the title and the yes-no statement certainly highlight the fact that there's voter confusion, but
doesn't the summary, I mean, if the summary mentions it, is that why you say it mentions it, but that's not good enough because they're unrelated? Is that how you get to the unrelated?
Right, and the fact is that the whole point of Article 48 is to prevent voter confusion, and sure, they can look at the summary, but our concern is that the provisions themselves are not accurately, they do the classic hitching, which is what the court was concerned of in pointing to the drafters of Article 48.
Well, let me ask you, what do we do if we agree with you? You essentially are saying the statement is not merely incomplete, but is misleading because it makes no reference to sale, but you have not, pursuant to the statute, challenged the single statement. Are you saying that we have the authority sua sponte to revise the statement even though you have not challenged it?
We're not asking the court to revise the statement. We're asking the court to enjoin placement of the petition on the ballot.
Apart from what you're asking the court to do you say that we have the authority to do it even if you do not ask us to?
No, we do not, Your Honor. We believe that that it's very clear the strict provisions required within Article 48 limit the options for the court. And it's
even with the yes-no statement?
As to the yes-no statement, yes, of course, you could correct the yes-no statement.
I think that's what Chief Justice Gaines is speaking.
But you haven't, but I mean, the question is, you did not, pursuant to the statute, challenge the yes/no statement? Or are you saying that even though you do not challenge it, we have the authority to revise it?
We are not asking the court to
I
revise it.
know you're not
and we
asking us
would-
to. I'm asking
and-
us about your understanding of our legal authority. I know you've not asked us to. I'm asking about whether or not we have the authority if you have, even though you have not asked us to.
I'm unaware of any case law, Your Honor, but would be happy to provide supplemental briefing on whether or not the court has authority to revise the yes/no statement on a sua sponte motion. We would point out that much like the dog racing industry in Kearney, the retail food industry is heavily regulated, and the burdens that are being placed on the retailers here are substantial and should be made aware to the voters.
Okay, but I mean, the summary mentions it. So the summary is not unfair, correct?
That's correct, Your
So
Honor.
you're saying they're not related, and I'm asking you to respond to the argument that they are related, because if you require farmers to give more space with regard to their raising of pigs and calves and hens, and you don't require stores to purchase only those items, those farmers are going to go out of business because the prices for their products are going to be higher than from those farms which are not limited by these restrictions.
The concern here, Your Honor, is not just within the restrictions within the confinement restrictions within the Commonwealth, but the supply of eggs, pork, and veal products that would come from beyond the Commonwealth, and the burden that will be placed on retailers in identifying sufficient products that would be affordable for the people of the Commonwealth to purchase.
Okay.
Because
This is not in the proposed law itself, right? The impact that you're discussing?
correct, the
So
impact.
why would it then be not something for debate?
That's precisely the current concern we have with the petition itself, is the fact that they say, we're prohibiting these confinement provisions, we're prohibiting confinement, but we're also prohibiting retail sales, and the retail sales, frankly, are going to come from beyond the Commonwealth.
Why isn't that a matter for public debate as opposed to challenging the initiative petition?
It is a matter for public debate that will be brought up, but the greater concern here is the hitching of the popular provisions regarding prevention of the confinement with the misleading and failure to identify the serious concerns that comes with requiring retailers to assume liability for the products that they are going to sell in their store when they're already regulated by the USDA as to food safety and concerns that happen there. Article 48 clearly says that the concern is to protect the voters from confusion, and certainly it can be part of the policy debate. Our concern is that the prohibition on animal confinement and the provisions regarding retail sales and the assumption of liability, including up to $1,000 a day civil penalty for failure to ensure that each of, not just the hens and not just the veal were raised in a particular manner, but that you go back to even the breeding stock of the pork to determine
Well, in
whether
a
or not it was
democracy
raised fairly.
where people vote on things, don't we kind of assume some intelligence and some inquisitiveness on the part of the voter? The Attorney General can't spoon feed the voters. The voters have to inform themselves. So you would expect that to happen, and why isn't that the answer to the question that you're raising here? That the Attorney General doesn't have to do that, the voters have to do something for themselves.
The voter does have to do something for themselves, but the problem is, even if you look at the plain language of the petition, it's not until you get, the petition is 4 pages long, and it's not until you get to the middle of page 3 that you fully understand the obligation that's being imposed on the retailers.
Well, so if it's further up in the draft, that would be better as far as you're concerned? I mean, it's there.
It is there. The concern we have is the hitching of the popular provisions at the very beginning of the petition concerning animal confinement practices, and not until much further down in the petition do you fully understand the full impact that this retail sale would have.
But you still have not responded to the question of why they are not related, in that the argument I understand would be that the sale prohibition is necessary if, in order to protect the farmers who comply with Massachusetts law, because as I understand it, the sale would affect veal that comes from Australia and Argentina just as surely as it does veal and pork that comes from Massachusetts. But why is it not necessary to protect the Massachusetts farmers?
Well, there's certain, I mean, yes, I suppose there's some economic protectionism that would be happening there with protecting Massachusetts farmers who would be complying with this confinement law. But the problem is it goes back to, we would submit that it's not sufficiently related for this confinement, and then to also have the separate and distinct retail prohibition. We would also, briefly, I want to touch base on the improper form of the petition 1511. Petition 15, or Article 48 makes no discussion about policy statements within the law. The lawmaking powers that have been reserved to the people under Article 48 are limited, and there's no mention of policy statements or findings of facts or conclusions of law.
Right, I mean, I get that argument, and if all that this petition spoke about was the purpose, then I would understand your point. But the purpose is only the first paragraph, and is not that purpose helpful to those who would be understanding the language of what follows in order to interpret the law? Is it not pretty typical of good legislation to clearly identify its purpose so that when courts and others are seeking to interpret the laws that follow, that they understand what was the intent of, in this case, the voters when they enacted it?
Article 48 doesn't provide that precisely, doesn't allow these policy statements. And yes, I can see where they're helpful, but the provisions within Article 48 are limited. And while those sort of policy statements might be helpful and appropriate in the legislature, the voters here are limited to what's said on the page, and whether or not the prevention of certain animal confinement practices advocate results in the risk of reduction in foodborne illnesses or negative fiscal impacts within the Commonwealth may not accurately be a description of what the voters intended in adopting this law. Our concern here is the specific policy statement is inaccurate, it is argumentative, and it has no basis in the facts that are contained within the language of the petition itself. And for these reasons,
All right, thank you.
further questions, thank you.
Good morning, Your Honors, and may it please the Court, Bessie Dewar for the Attorney General and Secretary of the Commonwealth. The Attorney General did not err in certifying Petition 1511. If I may, I'll start with the relatedness issue. I think that going back to this current court's Carney decision, this court said the crux of the question is whether the similarities dominate, and such that the voters have a clear, coherent yes or no choice to make. I think here it's very clear the similarities dominate. We have a statement of purpose to reduce animal cruelty by phasing out certain methods of confinement, and essentially two mechanisms for achieving that aim, namely the confinement ban and then the ban on sales of products derived from such confinement. I frankly think that those demonstrate a high level of operational relatedness, as this court required in the Carney decision. So I think it easily clears that hurdle.
Now, just to be clear, I'm correct, am I not, that with regard to the sale of pork and eggs and veal, it would affect not only Massachusetts pork, veal, and eggs, but that purchase from Chile, Argentina, Australia, Iowa, California?
You're correct that it governs all sales of these products in Massachusetts, no matter the source of the product. Of course, farmers in New Zealand and California would be free to raise their animals however they wish. They just could not sell in Massachusetts.
So I'm a store owner. I buy stuff through a distributor who buys meat from all over the world. How do I know whether the animals involved were treated this way in Australia, New Zealand, Chile, California? How do I know that?
Your Honor, the statute contemplates a sort of certification process that would exist. And obviously, one of the plaintiff's arguments here is that this law simply goes too far, right? The confinement ban is fine, but the ban on products is too onerous. And we would submit that's a question for the voters to decide.
Who's certifying to what? So the people, I as a store owner, I have to get certification from anyone who sells to a distributor that I buy from with respect to meat products produced in other places?
I believe what Section 7 of the law provides is not a requirement that anyone obtain a certification. It simply says that a store owner will have a good faith defense if the store owner has obtained a certification that the products met the standard. So it's simply a good faith defense
safe
that will
harbor.
exist, a safe harbor, if you will. It's not an active requirement.
Do you
Now-
have a view, I'm sorry.
No, go ahead.
Do you have a view as to Chief Justice Gantz's question addressed to the plaintiffs? That is, if the summary doesn't, if the yes, no statement doesn't include anything about sales, is the court authorized to change that even though it hasn't been requested?
If I may, I have two responses to that question. So first of all, I would refer to the court to Chapter 54, Section 53, which not only requires the yes-no statement, but in particular states that this court, upon a challenge, may order the Attorney General and Secretary to correct the yes-no statement, quote, only if it is clear that the sentence is false, misleading, or otherwise inconsistent with the statute's requirements. So I don't think that Section 53 contemplates that this court will undertake a redrafting of the yes-no statement, except in specific circumstances. But with respect to whether it is clear in this case that it's false, misleading, or otherwise inconsistent with Chapter 54, Section 53's requirements, I don't think it is. It refers to a prohibition on these methods of confinement.
If it is, do we have the authority to correct it sua sponte?
I would think that if this court believes that it is clear that it is false and misleading,
Well, it doesn't have to be false.
it says false. I think Chapter 453 says, Section 753 says, only if it is clear. The exact term is only if it is clear that the sentence is false, misleading, or otherwise inconsistent.
Or,
So it doesn't have to be false and misleading. It
No,
just can
no,
be
sorry, I didn't mean to say-
misleading and otherwise inconsistent.
Correct. And
So you do think we have the authority to do it sua sponte? I guess I want the answer to that question.
given that the plaintiffs didn't challenge the yes-no statement, I'm afraid I have not briefed the question whether this court has sua sponte authority to address that question. I would think that because the statute provides that the court may order the Attorney General to correct the statement if it is false, misleading, et cetera,
But does
I
the-
suppose the court could.
On a challenge to that.
The prior, if you look at the actual section, there's one sentence that says a person, that the Attorney General may do this, and then challenges may be filed, and then the next sentence says the court may, order it in these circumstances. I think that probably the legislators intended that in the context of a challenge, the court could order that relief, but it doesn't exactly say if such a challenge is filed, comma. So I think that perhaps this court does have that authority. I don't think that that's necessary here. It refers to, the yes-no statement says that this would create a prohibition. I think it does on these methods of confinement. I think it creates a prohibition through two mechanisms. First, directly prohibiting these forms of confinement, and then second, prohibiting the sale of products derived from
right,
such
but it makes no
confinement.
reference to the sale.
What I'm saying is I think that that's a sort of a backup, additional method for prohibiting these.
I mean, everybody in this state are consumers. The sale matters to everybody. The cruelty perhaps should matter to everybody, but how can you not make any reference to the fact that it would prohibit the sale, and when the prohibition extends beyond Massachusetts, but to any producer around the world? I mean, why is that not misleading?
I'm not sure that it's misleading, Your Honor, in this sense. I agree that the Attorney General could have, and the Secretary could have included it, and made a longer sentence. But the Secretary and Attorney General were endeavoring to have a short description of the law, and I note that the sentence does say specifically which animals are involved. So, there are judgment calls that have to be made. Should we just say farm animals? Well, in that case, then there's a problem because it's not all farm animals, it's just specific farm animals. So there are always judgments about how much detail to include. And I would note, for example, if there were a law that prohibited, I don't know, cars without airbags, and it both prohibited the manufacture of cars without airbags and it prohibited the sale of cars without airbags, no matter where they were manufactured, I think you would just generally speak of that as a prohibition on cars without airbags with two mechanisms for its implementation. So I think that's how the word prohibition is intended here. I agree that it could have been drafted in a different way, but I don't think that it's false, misleading, or not in conflict with the requirements of Chapter 54, Section 53. If I may, I'll just turn briefly to the statement of purpose issue. Nothing in Article 48 or this court's cases suggests that a law is not a quote-unquote law for Article 48 purposes simply because it includes a statement of purpose. As Your Honors were discussing, that's a typical feature of laws passed by the legislature. This court has often held that except with the exception of the explicit requirements in Article 48, the people's power to pass laws is coextensive with that of the
I
legislatures.
note that the marijuana one has a specific, the first section is, it is the purpose of this, as Mr. Kiley said, the purpose of this law is to do X, Y, and Z, so.
Indeed, and we've included in the record appendix at pages 56 to 100 a number of, I think, 10 different other laws proposed by the people since 2000 with statements of purpose. So it's clear that, first of all, I don't think that the court should read in and create out of whole cloth a new requirement. It's also clear that that would definitely restrict the people's lawmaking because until now, the people certainly have, like the legislature, included statements of purpose with obvious reason because it's helpful to say what the purpose of a law is. If this court,
What title is given to this particular provision?
the title of it is called, I believe it is called, An Act to Prevent Farm Animal Cruelty. Sorry, that's the title of the actual
Right.
provision.
What's the title which you propose to be on the ballot?
The title proposed to be on the ballot, I believe, is conditions, pardon me, I will look it up. I apologize that this is not at the tip of my tongue.
Nor is it at ours, apparently.
I believe it's in the record appendix at pages, hold on, let me pull it up.
Yeah, I couldn't find it, but I don't.
131, I have kind help from behind me.
31. So it's conditions for farm animals.
Conditions for farm animals, yes. I apologize for the length of time it took me to find that. Anyway,
Okay.
if you have no further questions, I would just ask that you please uphold the Attorney General's certification of Petition 1511.
We will, I'm sorry, we have to hear from Mr. Bean, and then remind me at the end to give you an opportunity to brief the matter that we just discussed, so.
Thank you.
And a colleague will elbow me if I've forgotten. Mr. Bean.
Thank you, Your Honor. May it please the Court, my name is Thomas Bean. I represent 3 of the first 10 signers of this initiative petition that the Secretary of the Commonwealth has certified has been signed by over 95,000 voters. I'm going to do my best to answer your question, Justice Gantz. I've been thinking about it for 10 or 15 minutes. The answer is I don't believe this Court has the authority to sua sponte modify the yes-no statement in this case. And
Even if it's before us.
I don't think it's properly before you.
Well,
And let me say, it's not, the reason I'm about to give you is not because the plaintiffs haven't raised it. It's because Chapter 54, Section 53 says, any 50 voters may petition the Supreme Judicial Court for Suffolk County to require that a title or statement be amended, provided, however, that the petition shall be filed within 20 days after the publication of the title and statement. I'm not certain about the timing, but I am certain that 50 voters have not challenged this petition. There are 2 plaintiffs in this case. And so I would suggest to the Court that this case is no different on this issue because there are only 2 plaintiffs, as if the initiative had not been challenged at all, because the requisite statutorily mandated number of plaintiffs have not brought this case before the Court. I think the answer may very well be different, as the Attorney General in the last case suggested, if there were over 50 plaintiffs and if the petition had been filed, as required by Chapter 54, Section 53, within the 20 days after the publication of the title and statement. So I think the answer in this case is very simply, no, this Court does not have sua sponte authority to modify the title, even if it thinks it's unfair, misleading, or false. And that's because the requisite number of plaintiffs.
Incomplete.
or incomplete,
But
whatever.
So if I'm understanding you correctly, you're also relying, as the Attorney General did, on 54, 53, but a different piece of it.
Yes, Your Honor. I think this case is as if it had never been brought on that issue because the requisite number of voters did not bring it, and I don't think that's questioned.
Okay.
I think the Attorney General has addressed the various other issues, and otherwise, unless there are other questions, I'd be pleased to rest on my brief.
All right. Thank you, Mr. Bean.